Oh, please mute your mics, okay? Do we have counsel for Joshua Marcus Ibiloma and Adefemi Adelekon Melrose Books? That's D.I. Omekwe. Is he on the platform? Mr. Omekwe is not around? Well, Mr. Omekwe must have had notice, and then I'll proceed to deliver the court's decision. Now, this is the court's decision. The claimant commenced this action via an origination summons filed on 18/10/2019 against the defendants. Upon application of counsel, the summons was withdrawn and struck out on the 6/12/2021 to pave way for the complaint filed on the 15/12/2021. By the aforementioned complaint, the claimant seeks the following reliefs against the defendant. One, a declaration that the termination of appointment of the... Please mute your mic, okay? Now, the declaration that the termination of appointment of the claimant by defendants without due process is null, void, and of no effect whatsoever. Two, a declaration that the claimant is an employee of the defendants and entitled to damages. Three, a declaration that the claimant is entitled to the sum of 6,390,701.66 in the special damages owed the claimant by defendants. Four, an order of this honorable court reinstating the claimant to the employment of the defendants with effect on 5/7/2019, or in the alternative, an order of the honorable court for aggravated general damages of 2 million naira for the defendants for the rancor, embarrassment, frustrations, and hardships suffered by the claimant as a result of the unwarranted actions of the defendant. Five, cost of this action. Now, I'll summarize the proceedings at trial and the case before the court and the submissions of the claimant in final address. The defendant chose not to put up an appearance despite several notices served on him. The claimant was allowed to proceed to file his final address, and same was adopted. And this is the court's decision. No need to go through all of that now. Now, this is the court's decision. Having carefully considered the processes filed by the claimant in support of the release claimed, I'll start off by reiterating the tried principle of law that the party is always obliged to prove what he asserts. The defendant here failed to defend this action, which necessitated the withdrawal of counsel that had entered appearance on their behalf. As it stands, there's nothing to contradict the claims and assertions of the claimant before this court. The burden placed by law on the claimant is therefore lighter. I've cited several cases to that effect. The claim for unpaid salaries and entitlements in the realm of special damages, which requires specific pleading and strict proof. Now, the claimant in paragraph 25 of the statement of facts provide particulars of these special damages. Page 2 of Exhibit C1 provides for the payment of 1 month salary in lieu of notice. Page 1 of the same exhibit provides for the payment of leave grant, while Exhibit C5 provided for the amount of 408,000 naira as the annual leave grant. Similarly, the claimant's last salary is stated on the face of Exhibit C5. By a memo dated 20th of September 2016, the claimant used the word shall. The defendants, I beg your pardon, use the word shall, which connotes a mandatory provision in providing for the payment of productivity bonus. By another memo dated 26th of June 2017, the defendants explicitly provided for the payment of 5% of any sales payment over 10 million naira. This is to be paid to the sales personnel. The claimant has shown by uncontradicted and cogent evidence that he secured for the defendants 2 contracts for supply of the defendant's books for 94,874,364 naira and 24,708,413 naira, which entitles him to the sum of 4,743,718.20 and 1,235,421.50 as 5% of these contracts. Also, the claimant has shown that the defendants terminated his employment without I beg your pardon, gentlemen. I have absolutely no idea what happened when it just went out. I'll continue from where I stopped. Now, I've painstakingly shown the facts that have been satisfactorily proved before this court by the claimant. The claimant's case, in my considered opinion, passes the twin test of proof of entitlement and the right of quantum claim. Parties are bound by their agreements, and no party will be allowed by the court to renege on terms and policies agreed with another in abuse of the dominant position. I therefore find that Relief 3 hereby succeeds and is so declared as prayed. Relief 2 also succeeds as it is this court's opinion that the claimant has proved that he was an employee of the defendant and has suffered damages due to the actions of the defendants after undertaking great risk in pursuit of the defendant's business. Relief 1 only succeeds to the extent that it is hereby declared the termination of the claimant's employment was without due process, but the court refuses the leg of prayer for the termination to be declared null and void. As a consequence, I must therefore refuse the main Relief 4, as the court cannot force an employer on an unwilling employer or nor force an employee to remain in employment, as that would amount to forced labor and not an agreement of the parties. Now, the law, however, is that where the main relief is refused, the court can look at the alternative relief. Alternative relief 4 is certainly grantable, as the claimant had established his right to the special damages enumerated in paragraph 25 of the statement of facts. I am also of the considered opinion that the claimant is indeed entitled to damages for the wrongful actions of the defendants in abusing their dominant position over a claimant who went over and beyond the call of duty in traveling at great risk to a stage driven by insurgency, only for the defendants to terminate his employment as a reward. I therefore award the full 2 million naira as general damages and the sum of 6,390,702.36 as the established special damages to the claimant to be paid by defendants. This to be paid by defendants within 30 days, failing which the monetary awards will attract 10% simple interest. Parties are to bear their respective costs. Judgment is entered up.
As the court pleases.
As the court please.
The court pleases.
As the court pleases.
As the court pleases. As the court.
Now, do we have counsel for Malanu Mohammed and Shunko Nigeria Limited? That is NICN/JOS/3/2019. Malanu Mohammed and Shunko Nigeria Limited.
Yes, my lord.
Yes, my lord.
All right. Can I have your appearances, please?
As God pleases.
Who appears for the claimant?
With most profound respect, I am Gwani. My lord, I appear with A.C. Ubale for the claimant.
Who appears for the claimant?
May you please, my lord? S.T. Dahile. I appear for the defendant.
I am Gwani.
Yes, my lord. A.C. Ubale.
I am Gwani with Ubale, right?
Yes, my lord. Claimant.
For the claimant? For the claimant? Yes,
Yes,
Mr.
sir.
Ahile for the defendant?
Yes, my lord.
All right, this is the cost decision. The internet connection is a bit unstable. That's why I'm brushing through this. Now, the claimant, this is the judgment of the court. The claimant commends this to via a complaint statement of fact dated the 7th of February 2019, but filed on the 12th day of February 2019, seeking the following relief against the defendant. Order declaring that the claimant's employment with the defendant is subsisting. 2, an order directing the defendant to pay to the claimant the sum of 3 million naira representing monthly salary due to the claimant from the defendant from December 2014 to January 2019. 3, general damages in sum of 2 million naira on the footing of mental torture and hardship imposed on the claimant by the action of the defendant. And 4, interest on the judgment sum at the rate of 10% per annum from date of judgment to liquidation of judgment debt and costs as assessed by the Honorable Court. Again, I've summarized the proceedings at trial, the case of the various parties, the two parties, the submissions of the defendants and final address, as well as the claimant. This is what concerns you, the court decision. I'm going straight to that. I'll start off with a resolution of the challenge to the admissibility of certain exhibits admitted in the course of trial. The legal counsel to the defendant raised objection to the admissibility of Exhibit C3 to C6. Exhibit C3 is a document showing instructions on how to open or close a Boyle safe. Exhibit C4 is an identity card with the claimant's photograph on one side. Exhibit C5 is a key, while Exhibit C6 is a printout or a copy of a printout showing the name of the defendant company and the names of 17 individuals listed alongside their designation and some figures for the month of September 2014. The law is that relevance governs admissibility. This much is right. However, where the law prescribes certain conditions for admissibility, these must be met. It is also beyond dispute that a court has the powers to expunge evidence wrongly admitted in the course of trial. I've cited several cases in support of this position of the law. Exhibit C6 was challenged on the ground that on the ground of a failure to front load it alongside the claimant's processes. The defendant here admitted that Exhibit C6 was pleaded. Now, I agree with claimant's counsel's submissions in paragraph 5.2 of the claimant's final address that the authority of Onoha citation provided applies here. This authority clearly addresses the new thinking in the resolution of cases, particularly the NICN. Rejection of documents because they are not front-loaded, though pleaded, would not be substantial justice. Pleading already gave the other party notice of what case he is to meet in court. Further, the defendant was placed on notice to produce the original of Exhibit C6. The defendant failed to comply with this notice. He did not deny that the original was not in his possession. He simply ignored the claimant's notice and now proceeded to challenge its admissibility. As aptly put in Ono as Supra, there is no law that says a document which is not front-loaded is inadmissible. The defendant submitted that Exhibit C6 is an unsigned document and therefore inadmissible. It may be true that an unsigned document is worthless, but it must be shown that this document ought to have been signed in the first place. I've carefully examined Exhibit C6 and I find no place for a signature on this document aside from the signatures against the names of the various individuals who appear to be recipients of payments against their names. With respect to legal counsel to the defendant, he cannot impose the condition for admissibility of Exhibit C6 when the law does not prescribe such a condition and say who. I therefore find in the circumstances of this case that Exhibit C6 is relevant, pleaded, and admissible. It will be considered in the resolution of the dispute between the parties and as a whole. Coming to the challenge of the admissibility of Exhibit C3, C4, and C5, the legal counsel to the defendant contends here that the documents were not pleaded. As the claimant counsel already pointed out, the claimant pleaded these documents in paragraphs 2 and 18 of the claimant's reply to the statement of defense. See also the claimant's additional deposition of 1/7/2019 in support of the reply to the statement of defense, particularly paragraphs 2 and 15. I therefore find no merit in the challenge to Exhibit C3, C4, and C5. They were rightly admitted and will be considered in determination of the rights of the parties and so forth. The claimant on his part challenged the admissibility of Exhibit D1 on the ground that Exhibit D1 is a fraud. It's a fraud and should not be ascribed any weight as it was purportedly issued on a public holiday. That the alternation on that year also renders it unreliable. I've carefully examined this document. I agree with defendant counsel that when an allegation of fraud is raised, it must be proved beyond reasonable doubt. This the claimant counsel has not done in my considered opinion. This leg of objection would therefore be discountenanced. However, the issuance of Exhibit D1 on the 26th of December raises questions in the court's mind as to its authenticity. While this is not conclusive proof that the document is not genuine, I've also considered the apparent lack of a name of the signatory to this document. It seems to me to be an afterthought on the part of the defendant. However, admissibility is distinct from weight. I'll find that while this exhibit has not been shown, Exhibit D1 has not been shown conclusively to be a fraud, it is admissible. The way to be attached to it will be determined later in the course of this decision. So, coming to the merits of the reliefs here, there is no evidence placed before this court showing the employment, there's no evidence placed before this court showing the relationship, the employment relationship created by Exhibit C1 had been terminated. While Exhibit C1 was clear and unambiguous as to what relationship it created, it was also clear as to how the employment contract could be brought to an end. See Clause 4, Exhibit C1. Most importantly, the context of Exhibit D1 did not expressly terminate the employment relationship between the parties. He simply thanked the claimant for his efforts and stated his entitlement for that particular project. One cannot read into a document what is not expressly contained therein. When married with the fact that Exhibit C1, which is the letter of appointment, did not state that the claimant was only employed for the purposes of the Bachaka project, it cannot now be taken that the Bachaka project, that as the Bachaka project was concluded, the claimant's employment effectively came to an end. I've also considered the testimony of both CW1 and CW2. I have in particular considered CW2. I testified in detail about the defendant's projects and the fact that he was thereafter suspended upon testifying for the claimant in this trial. In his words, I quote, "I was suspended because of this testimony. When I gave my statement on oath, I was an employee of the defendant," end quote. Proof in civil cases is on the balance of probabilities. Several cases to that effect. Now, with no evidence of a redundancy declared by the defendant and attendant laying off of staff, and with no termination letter issued to the claimant, and with the believable logical testimony of the claim, gentlemen, can you hear me now?
Yes, my lord. Loud and clear.
Yes, my lord.
I've decided to switch internet service providers. Let me see whether it's from my own end. Now, sorry, I'll continue from where I stopped. Now, I've considered the testimony of both CW1 and CW2. I have in particular considered that CW2 had testified in detail about the defendant's projects and the fact that he was thereafter suspended upon testifying for the claimant in this trial. In his words, quote, "I was suspended because of this testimony. When I gave my statement on oath, I was an employee of the defendant," end quote. Proof in civil cases is on the balance of probabilities. I've cited several cases to that effect. With no evidence of a redundancy declared by defendants and attendant laying off of staff, and also with no termination letter issued to the claimant, coupled with the believable logical testimony of the claimant as corroborated by CW2, I find that the claimant's case is more probable than the defendant. Relief 1 therefore succeeds and is hereby declared that the claimant's employment with the defendant is subsisting. For Relief 2, the claimant was employed as an accounting assistant on an annual salary of $2,160,000. However, Exhibit C6 shows the claimant's monthly salary was $53,104. This exhibit was issued in September 2014, and the claimant claims his salaries from December 2014 to January 2019. In the absence of any evidence to the contrary, the court is obliged to accept the sum of 53,104 naira as the claimant's monthly salary. The period between December 2014 and January 2019 is 49 months, and at a monthly salary of 53,104 naira, it's 2,602,096. This is what the claimant is entitled to, and not the 3 million naira as claimed. A court can award a sum less than claimed if satisfied that such has been proved, but they cannot award more. I've cited several authorities on that to that effect. I therefore award the sum of 2,602,096 as the claimants are paid salaries for this period of December 2014 to January 2019. General damages flow from the wrongful conduct of a defendant which do not have to be strictly proved, unlike special damages. I am satisfied in the circumstances of this case that the defendant's actions have caused hardship on the claimant, which the court can remedy. I therefore award the sum of 500,000 naira general damages in favor of the claimant to be paid by the defendant. The successful party is also entitled to the award of cost of action that he was forced to file for the wrongful acts of the other party. I hereby award the sum of 200,000 naira cost of this action, which has lingered from 2019 to 2023. All monetary awards are to be complied with within 30 days, failing which they will be attracting % simple interest. Judgment is entered accordingly.
As a court pleases.
As a court pleases.
You get a copy. Well, I'm not sure, maybe after Salah, because I'm sending it to Jos.
My lord, do I have a consequential order to seek, my lord? If may be obliged. We have a consequential prayer following from the judgment, my lord.
What order do you want?
My lord, arrears of salaries from February 2019 to March 2023 as estimated by the court, my lord. And salaries monthly until his employment is legally terminated or determined.
You're making the prayers now?
Yes, my lord. Consequentially, I have authorities to that effect, sir.
No, you have not put the other party on notice. You cannot spring a surprise on Mr. Ahile.
My lord, on the authority of Okoye versus Chief Lands Officer.
You cannot, in the interest of justice, you cannot spring a surprise on Mr. Ahile.
My lord, on the strength of the first relief sought and granted, sir.
You sought the relief that the order that his employment still subsists, right?
Yes, sir.
He's still in the employment.
Yes, sir.
So if he's still in the employment, you sought an order that stopped in 2019, right?
Yes.
Award of salaries to 2019.
Yes, my lord.
This was what the court granted you, right?
As the court pleases.
Now, from 2019 to 2023, if you want the salaries from that day, you should have made it an issue in your pleadings so that Mr. Ahile could have responded.
My lord, on the authority of Idigbe and Okpokiri,
yes,
authorities are able to, my lord is empowered to give effect to your judgment, my lord, without the need to.
Wait, that is when you need to give a consequential order. Is that what you're saying?
Yes, my lord. We're saying that the
consequential order, Mr. Gwani, right?
Yes, yes, my lord.
Is to give effect to the judgment.
As the court pleases.
Right?
Yes, my lord.
So that a judgment is not given in vacuum and becomes unenforceable. Right? Wait, hold on, Mr. Ahile.
I'm not done.
Martha, mute your phone, please. Right? Now, Mr. Gwani, what you're asking for is not a consequential order. You're asking for a fresh relief here. Right? A consequential order is not, the court can award what you do not ask for to give effect to the judgment.
As the court pleases. Right?
By awarding salaries now from 2019 to 2023, it is not to give effect to this judgment. Because now the court has declared that he is still in employment, it naturally follows that he should be paid from 2019 to 2023. That is correct.
As the court pleases.
If they fail to do so, do you know whether they will do so or not?
I'll be better protected by an order of court, sir.
An order of court, then make, I don't know whether you now have another course of action. I will not do your work for you, but it is not a consequential order that you will seek now. It's not to give effect to the judgment. The judgment is that I awarded you the salaries you asked for. He's still in employment.
As God pleases.
Mr. Ahile, do you have anything to say?
Yes, my lord, we thank the court for the well-considered judgment. We'll advise our client accordingly.
No, yes. As per the issue of the consequential order, Mr. Guani seeks for the court to award additional salary from 2019 to 2023. Do you agree that the court can do that?
No, my lord.
That is not a consequential order.
That is a different relief he's asking.
You should have joined issues on that. Consequential order, it is going to give effect to the judgment. I've made an order for payment now, right? If there are certain circumstances now that in the course of the decision necessitates the court making an order of how the payment is to be made, so that it will not be judgment given in a vacuum, a Pyrrhic decision. That is when the court will now give a consequential, as a consequence of it, not for a fresh relief, Mr. Guani.
As God please.
The internet connection is unstable, so I better proceed to the last judgment. Thank you, gentlemen.
Most guided.
You will have your decisions. I don't know if Friday is a public holiday, but I'm sending them to Jos by tomorrow.
As God please.
So you should be able to speak to the registrar.
As God
please. Right.
Hello. Hello.
Yes.
Good morning, my lord.
Good morning.
Sorry, I had a little difficulty connecting. I don't know what happened, but I'm just on now.
Okay. And your name is?
Ralph A. Moye.
Ah, Mr. Moye.
Yes, sir.
Please hold on for a minute. I need to read one more decision, and then I will call up your matters.
It's okay, sir.
All right. Do we have counsel for the carrier Alsaka versus Sodex Mines Limited?
Yes, my lord.
Ali?
Yes, my lord.
A.S. Masala?
Yes, my lord. For the claimant, my lord.
For the claimant, right?
Yes, my lord.
And Mr. Ahmed Alkani? Who appears for the defendant?
It's supposed to be Mr. Akani.
Well, if he's not here, the court is going to proceed either way. Now, this is the court's decision.
As the court
the claimant commenced this action by way of complaint and statement of facts filed on the 17th of March 2021, seeking the following relief against the defendant. A declaration that the claimant to be paid the sum of 43,000 USD and 43,400 USD only as accumulated salary and allowances of the claimant from November 2019 to November 2020 by the defendants. A declaration that the claimant is entitled to be paid the sum of 750,000 naira only as the claimant's house rent allowance for the year 2020 by the defendants. C, an order directing the defendants to pay the claimant the sum of $43,400 only as the accumulated salary and allowance of the claimant from November 2019 to November 2020, and an order of directing the defendants to pay the claimant the sum of 750,000 naira as the house rent allowance for the year 2020, and an order to pay the claimant the sum of 750,000 naira as solicitors' fees paid to A.S. Masala and Co., as well as the cost of proceedings. Now, summarize the proceedings at trial, the case of the claimant, the case of the defendant, submissions of the claimant in final address. The defendant elected not to file a final address, so the claimant was allowed to file a final address, which was adopted, and this is the court decision. I've carefully considered the contentions of the parties here, as well as the limited evidence placed before the court. The duty is always on he who asserts to prove what he claims. The claimant here contends that it was Exhibit C3 that created the employment relationship between him and the defendants. The defendants have disowned this document. The only evidence of the defendant relied upon in denying the authenticity of Exhibit C3 is the averment of DW to the effect that he was not issued an employment letter. DW did not, however, contend or show that he and the claimant were either employed at the same time, or nor was there any supporting evidence for this contention. The defendant obviously here is unaware of the failure to issue an employment letter to an employee is a violation of the Labor Act. But as the parties have not joined issues on this at trial, the hands of the courts are tied as to this particular issue. However, I find that the defendant has placed no cogent evidence nor furnished the court with a credible reason to believe the story that Exhibit C3 was not issued by the defendants. It is therefore this court's finding that the Exhibit C3 represents the contract between the parties and will be treated as such and as a whole. Now, while Exhibit C3 shows the monthly salary of $1,000, which was corroborated by defendants in paragraph 4 of DW's deposition on oath, there's nothing before this court that supports the contention of the claimant that he was entitled to $1,800 as monthly salary and $500 as monthly allowance. There's also nothing before this court to show the entitlement to the annual $1,000 airfare allowance to Syria. Same applies to the 750,000 naira rent allowance. Courts do not grant relief without proof of entitlement or merely for the asking. The reliefs before this court are in the realm of special damages. I'll here refer to RCC Nigeria Limited versus Edomo Win citation provided, where a BAA JCA held as follows, and I quote, it is tried that any loss of earnings is a claim for special damages in the sense that full particulars must be given by the plaintiff in his pleading of his rate of earning and such other facts as may be necessary to enable the court to calculate as best and as accurately as can. See Osei Mon was Ojo and Benin Rubber Products was Ojo citation providers, end quote. Now, for special damages, not the oral testimony of a claimant except if corroborated by other credible evidence sufficient to establish an entitlement. See Mr. Joseph Akinola and others versus Lafarge, WAPO Nigeria PLC, citation provided, which specifically cautioned against the reliance on an oral contract as proof of such entitlement. Because the claimant is claiming for unpaid salaries, he must show that he was an employee of the defendants, as Hoff Sawmill was Hoff citation provider puts it, between an employer and an employee, the onus of an employee to prove that the employer employed him on a stipulated salary and that he worked for the employer during the relevant period. It is when the employer decides his burden that the burden shifts to the employer, right? Now, at the risk of repetition, I must state again that Exhibit C3 does not show the claimant's entitlement to the sums of $1,800 and $500 monthly. There are no bank statements, no any vouchers placed before the court to this effect, no promotion letters, and certainly no pay slips. At this point, I'll refer to the dictum of my learned brother Kanyip J. now PA NICN, which though persuasive are filed after and applicable here. His lordship held in Mr. Mohammed Dungus and others was ENO consortium citation provided that, and I quote, this court has said that the rule is that the claimant who claims must prove, and in labor relations, an employee can only claim if an entitlement is shown. An entitlement is shown by reference to the law that gives it the collective agreement from which the entitlement was agreed on between the contracting parties, or the conditions of service governing the relationship of the employer and his or her employee. Secondly, the employee who claims must show how he came about the quantum of the sums claimed. This court also cautioned that it may be fatal if improving an entitlement, and even if the instrument is referred to, the employee does not indicate the clause, section, article, or paragraph that grants the entitlement claim, given that the employee should not expect that it is the court that will shop for relevant article that substantiates the claim paid for. This is the context within which the claimant can succeed in the present case, end quote. I find the claimant case fails the test as enunciated in Dungu Supra. It lacks merit and is unproven. I therefore refuse all the reliefs here and dismiss the claimant's case accordingly. Judgment is rendered accordingly. Now, for the counterclaim, I find it a bit perplexing that the counterclaimant will make a claim for an order to set aside the defendant to the counterclaim's letter of appointment. In view of the court's finding in the main suit that Exhibit 3 is genuine, I must, in the circumstances of this case, refuse to relieve B of the counterclaim and is hereby dismissed accordingly. If A of the counterclaim must also fail for lack of evidence, the counterclaim man does not furnish any evidence in support of his right to this relief. It therefore fails and is hereby dismissed accordingly. Is hereby dismissed. Judgment is entered accordingly.
So, court, please.
As the court pleases.
Yeah, you can pick up on maybe Wednesday, Thursday. If I don't know when when is the public holiday? When is Eid al-Fitr?
It's supposed to be Friday. Well, I'm not mindful of it.
Well, it should be in Jos latest by Wednesday. But I don't know. You can pick up within the week, certainly within the 7 days before as allowed by law, right? Thank you, gentlemen. Now, Mr. Moye, which one is your matter?
It's Emeka Weluzo, Mr. Emeka Weluzo. Emeka Henry against Emmanuel Mamidu.
All right. Who is counsel?
Sorry, my lord.
Who is counsel on the other side?
My lord, I'm here. Dike Daron, sir.
Okay. Hold on, please. Let me sort out your file.
All right, sir.
What is the position?
So we have a motion to regularize our statement of defense, which was filed out of time.
Let me pick your appearances first.
My lord, my
Yes,
name is
Mr.
Ralph. My name is Ralph A. Moye.
Yeah,
Yes, appearing with me Esther Olaolu Esquire.
with Esther
Olaolu Esquire.
Olaolu.
Esquire.
And yes,
Then P is Kum.
P.
Kum Esquire.
Yes,
And DR Megida Esquire.
DR Megida.
Yes, our humble appearance, my lord, for the claimants.
Yes, please. Who appears for the defendant?
Yes, with profound respect to my lord, DK Darwan is my name.
DK.
Darwan.
Spell it, please.
DA.
Yes.
RW.
RW.
ANG.
ANG. For the defendant, right?
The defendant applicants.
Yes, Mr. Darwan, you have an application?
Yes, we have an application, my lord. The application is dated the 31st day of January 2023
Filed.
and filed on the 1st February 2023.
Mr. Moye,
Yes, my
are you
lord.
opposed?
Yes, I'm opposing because the application is incompetent. Order, my lord.
Hold on. Incompetent on the grounds that
On the grounds that they did not even exhibit the statement of defense to this application. This is a second application coming in series. The first one was dated 2nd of June, which was struck out. Now this one was dated 31st January 2023, and still they did not exhibit the statement of defense. They did not exhibit it. They had 9 paragraphs. They didn't say anything about it in it.
Mr. Darwan,
Yes, my lord.
by your application, you want to withdraw the motion of 2nd of December, right?
Yes, my lord.
And you want the court deeming the default fee paid in respect of the above as duly paid for this motion, right?
Yes, my lord.
So you want extension of time to file your statement of defense, right?
Yes, my lord.
And you file separate processes?
Yes, we filed separate processes. The statement of defense was already filed. It was before the court. So the motion that was earlier filed was to deem the earlier motion, the earlier statement of defense.
Yes.
So we noticed a discrepancy, my lord. So we had to bring this motion to make everything tidy at the processes before the court.
If I recall correctly, you came under the High Court Civil
Yes,
Procedure Rules of Plateau State.
the former motion, we used the wrong heading, my lord. We used.
You brought it under the High Court Rules of Plateau State.
Yes, instead of industrial court. That was the problem with the motion, my lord.
Mr. Moye.
Yes, my lord. You see, in this
have you been served with a clean copy of the statement of defense?
They did not. That is the one of 2nd of December, which has nothing to do with this application, which the court should look at of call for the paragraph statement.
What Mr. Darwan is saying, right?
Yes,
there already is a statement of defense, albeit filed out of time.
that one has been struck out, and whatever is tied to it is struck out. What is struck out? When it's
Maybe
filed
guided with the court record. It wasn't struck out, my lord.
Hold on. Mr. Monye, that application was not withdrawn, neither was it struck out.
Okay, so let it be struck out. Then we will make the rescue application. Then, secondly, my lord.
No, Mr. Monye. Mr.
Yes.
Monye, on the 1st of February 2023,
Yes.
right? Mr. Daron was in court, you were in court.
Yes,
right?
Lord.
Mr.
Yes.
Daron informed the court that he was unable to make payment of filing fees, right?
Yes.
And costs were awarded in your favor on that day,
Yes.
right?
Yes, I was coming to that, sir.
And he has not been paid. You have not been paid.
Up till now, he has not paid that cost.
And then he has no right of audience.
There's no right of that. I was coming to that, sir. He has no right of audience in this court, but he has not paid. He's in defiance of the court order. It's in defiance of the court order and making mockery of a litigation.
My lord, the money is with me presently. I don't know who will do our utmost best. The delay was caused by our clients, my lord. So the
Costs were to
and
be
the
paid
delay
within
was
7 days, Mr. Daron.
Yes, my lord. We will make available the funds, my lord, to my learned senior immediately after this sitting, my lord.
That was not the order of court. I will not take the
Sorry, my
application.
lord. We're sorry,
I will not take the application till you comply with the order of court.
As the court, please.
My lord, the court made an order that he should pay within 7 days, and it's now over a month and a half. So that is in defiance of court order.
That is why I will not take the application.
Yes, sir. And we're entitled to more damages for that.
My lord, we plead for another day to make the necessary payments.
Collect the first one, Mr. Monye.
Yes, sir. We will be asking for costs for that because this one is punitive.
Collect the
cost.
first one. Collect the 30,000 naira first now.
Yes, but this one.
You have
now
not collected the first one. You want some more?
Yes, but let it be in the proceedings. We're asking for costs for this.
I will not grant costs now.
As the court pleases, my lord.
Resumption would be 2nd of. There's a salad, then there's midday, right? So
yes, sir.
2nd 5/2023 for hearing of pending application, because I would not take this application unless the order of court is complied with. Unless Mr. Daron complies with the order of court. So matter adjourned to 2/5/2023 for hearing of pending application.
As the court pleases.
Mr. Daron?
Yes, my lord.
If you do not comply on that day, believe me, I'll impose additional costs.
As the court pleases, my lord.
You know, it's very easy. It's very easy for this court to impose costs.
Yeah,
and the next one will not be 30,000.
But my lord, you remember you said that if you did not obey the order of court, the court will impose additional costs. That's what you said the last.
This is Easter period, forgiveness.
Yes, my lord.
So we have given them a second chance. If they do it again, problem.
My lord, please, I didn't get the adjourned dates, my lord.
2nd of May.
2nd of May, as the court pleases.
Mr. Moye, 2nd of May for hearing of the application.
It's okay, my lord.
All right. Do we have counsel for Mr. Beatrice Ishaya again? Thank you. Have a good day, Mr. Moye. Mr. Beatrice Ishaya again. Mr. Beatrice Ishaya Young and Breaking Lady Local Government. Mr. Beatrice Ishaya Young and Breaking Lady Local Government. No counsel? Because once we go beyond it, I will not go back to any particular matter. Is there any counsel?
Yes, my lord, we are here for the defendant.
For Breaking Lady?
Yes, my lord.
And your name is? What is your name?
I'm CR Nanmiap.
CR.
CR Nanmiap. Nanmiap is spelled N-A-N. M-I-A-P, my lord.
Yes. Who represents the defendant?
No, I represent the defendant, my lord.
Oh, sorry, who represents the claimant? There's no representation for the claimant on the.
Yes, Barrister Elisha. I think he was online.
Yes, what is the position, Mr. Kanyip?
Yes, the matter is actually slated for hearing, but
Yes.
they have filed a motion for amendment. So ordinarily, they could have taken that motion today. I don't know what happened. We spoke with him this morning, and we're
motion
both
for
online.
amendment, right?
Yes, amendment of his motion for
amendment
of his motion.
Amendment of his motion or his complaint?
No, amendment of his complaint. Sorry, my lord.
They are not here today, right?
Yes, I don't know what happened. He was actually online.
2nd of May 2023 for hearing or pending application.
Sorry, my lord.
2nd of May 2023 for hearing or pending application.
As the court pleases, my lord, much grateful.
Hearing notice on the claimant, please.
As the court pleases, my lord.
Mr. Amushi Mabayat and Federal Civil Service Commissioner, Accountant General. Do we have counsel?
The counsel for the claimant applicant is in court, my lord.
Yes.
Yes, my lord. With profound respect, I'm M.W. Mafwe. M.W. initials Mafwe, my lord.
For the claimant, right?
Yes, my lord. For the claimant applicant, my lord.
Yes, please. Who represents the defendant? He's not here?
My lord, I spoke with the counsel to the respondent.
Yes.
And he told me that Mr. S.D. Lafat, who is within jurisdiction, will be holding his brief. And I spoke with Mr. Lafat before joining.
My lord, sir, can the court hear me?
Yes.
My name is S.D. Lafat, Esquire.
S.D.
Lafat, L-A-F-A-T.
You're for the defendant?
For the respondent, sir. Defendant, respondent.
Yes.
I'm holding the brief of Zachary Abdullahi, sir.
Yes, claimant, what application do you have?
Yes, my lord, we have an application before my lord to seek the leave of court.
Yes.
To set aside its order for hearing, my lord.
To set aside its order?
Yes, my lord. The order of the court region prosecution, my lord.
Sorry?
My lord, we have filed a motion with about 7 prayers, my lord. But the bottom line is to release the suit.
Release the suit.
Yes, my lord.
So why were you not in court?
Well, my lord, the reasons are enumerated in the affidavit, my lord. The counsel was served, but he didn't notify the applicant, my lord. And so applicant was not in court, neither was the counsel in court on that day, my lord.
Read prayer 7.
Well, yes, my lord, we intend to withdraw prayer 7 before moving on, my lord.
Exactly. I wanted to also would have raised issue on prayer 7, my lord.
Yes, my lord. We are withdrawing prayer 7, my lord.
So aside from prayer 7, the defendant has no objections to the grant of this application.
My lord, I'm not objecting, but for prayer 7, which is for me, is ungrantable.
You did not raise it. The court raised it. That's why
we have already withdrawn that, sir.
Yes, sir.
Aside from prayer 7.
Yes, sir.
Do you have any other problem with the grant of the application?
No, my lord.
So you have an application filed when?
My lord, the application is dated 12th day of January 2023.
Yes.
Yes, and it was filed on the 18th day of January 2023, my lord.
And you withdraw prayer 7?
Yes, my lord, we hereby apply to withdraw prayer 7 on the motion paper, my lord.
Mr. Lapat is not opposed, right?
Yes,
I'm not opposing, my lord.
We therefore move in terms of the motion paper and urge my lord to grant the prayer of the applicant. We are much obliged, sir.
Application file 122 is hereby granted in terms of prayers 1 to 6 only. Prayer 7 having been withdrawn by counsel is hereby struck out, matter adjourned to 3/5/23 for hearing.
As the court pleases.
We are much obliged, my lord.
We are grateful, sir.
Mr. Samuel Godwin. Invited home. You have counsel?
Samuel Godwin is in court, my lord.
Who is counsel for Mr. Samuel Godwin?
Beatrice Dung.
Mr. Dung, I have a problem with taking your application online. You have an application for Ganishi Order 9, right? Mr. Dung, let me take appearances first. Mr. Dung.
Yes, my lord.
Right?
That's the court is still.
For the applicant, right?
Yes, for the claimant, yes.
If you are not partaking in any particular suit, please mute your mics, gentlemen. Unless you are involved in that particular suit, don't mute your mics. Yes, Mr. Dung.
Yes, my lord. Our motion is not a Ganishi.
Yours not a Ganishi. You want to amend, right?
Yes, my lord.
Who is opposing counsel?
I am T.M. Ochibo, my lord.
TM Ochibo.
Yes, my lord.
Mr. Ochibo, are you opposed to the grant of this application? Mr. Ochibo? Mr. Ochibo, can you hear me?
Yes, my lord.
Are you opposed to the grant of this application?
I'm not opposing. I am not opposing on terms.
Mr. Doom, identify application.
My lord, before this honorable court, two motions. The first one dated. Which one is this one? I will do this one. Okay. First one dated 24th June 2022.
Yes.
And filed on 29 June 2023.
Yes.
And the other one. No, you seek to withdraw that. Yes, I applied to withdraw the one filed on 29 June 2022.
So Chubo is not opposed, right?
Yes, yes, my lord.
Motion filed 26. So motion filed 26, 29/6/22 hereby struck out upon application of claimant counsel.
As a court, please.
Yes, Mr. Doom.
Yes, my lord, before this honorable court is a motion dated motion on notice dated on the 8th of March 2023 and filed 6 April 2023. Motion not be opposed. Apply to move in terms. And
how many days do you want?
My lord?
Mr. Chubo is not opposed, right?
Yes. Yes, I'm not opposing, but I shall be asking for cost. Cost of 50,000 to be paid. If we have to go back and amend our statement of defense and so on and so forth. Almost good.
Motion file 6423 is hereby granted. Claimant has 7 days to file his amended processes, while the defendant has 7 days to file his consequential amended processes. Cost of 20,000 naira awarded in favor of the defendant to be paid by the claimant within 7 days. Matter adjourned to 4/5/23 for hearing.
And the call.
My lord, the date again.
4/5.
Okay.
Yeah, I'm not joking. I'm not joking.
Don't worry.
Comrade Janet is down for others. Comrade Janet is down.
Yes, my lord.
Yes, who's counseling the matter?
Good morning, my lord.
Morning.
Yes, my lord. I appeal for the claimants, my lord.
Yes. And your name is?
I'm A.I. Madaki, my lord.
Yes, please. Who appears for
Yes,
the
my lord. I
defendant?
appeal for all the claimants. Okay. Thank you, my lord.
Who appears for the defendant?
Please, my lord, Anthony Tejere.
Anthony.
Tejere is spelled I-T-E-D-K-E-R-E.
ITE. Sorry?
Yes, my lord.
ITE.
Yes, my lord. G-J-E.
GJE.
G-J-E. R-O-E.
RE.
R-O-E. Yes, my lord.
For the defendant,
For
right?
the defendant. Yes, my lord.
Yes.
Yes, my
Mr.
lord.
Malaki.
Yes, my lord. Most of blood, my lord. The matter is slated today for hearing, my lord. On the originating summons, my lord. From the processes before, my lord, issues have been joined and we are ready, subject to your convenience, my lord.
Defendant is ready as well.
My lord, we have a preliminary objection, which we have filed, and at the last adjourned date, my lord said the originating summons will be had together with the preliminary objection. We have filed our counter as directed by the court at the last proceeding, and we are ready.
I remember now. We'll do it on the 2nd of May.
Yes, my lord.
We'll do it on the 2nd of May in open court.
As the court pleases. We are grateful to my lord.
2nd of May, yes.
Okay. Most
My
of
lord,
them,
1st of May, my lord, 1st of May is supposed to be workers.
Second
yes,
of
my
May.
lord. Well, my lord, I was wondering whether the 2nd will not be a public holiday. That's why I was trying to call my lord's attention to it.
2nd of May, isn't it a weekday?
Let me confirm, my lord.
It's a Tuesday.
Yes, my lord. 2nd is a Tuesday, 3rd is a Wednesday, like that, my lord.
They don't give 2 days for workers, only for religious festival.
No, it's one day. I just wanted to be sure to look at the diary to be sure. Yes, my lord, it's a Tuesday.
Look at the diary, counsel.
I'm sorry, my lord.
2523 for hearing of originating summons.
We are grateful.
As the court pleases.
Thank you so much, my lord.
My lord,
thank you for accommodating us on this platform.
Yes.
My lord, I'm sorry, my lord.
My lord.
Yes.
Hello, my lord.
We had a preliminary objection. My lord said it's for the originating summons. What about our preliminary objection, my lord?
Of course, everything will be taken at the same time so that you would have one composite decision.
As the court
pleases. Because sometimes counsel will come to court to argue the preliminary objection is not part of it. That's why I'm raising it now.
No, you must be ready to. Have you filed processes?
Yes,
very well, my lord.
Then you adopt your processes on the 2nd.
Thank you, my lord.
Both for the preliminary objection and your response to the OS.
As the court
pleases. We are very grateful.
Thank you so much, my lord.
See you on the 2nd of May.
My lord, we are grateful.
The court pleases.
Mr. Joseph
Good morning,
Malia.
my lord. Good morning. Good morning, my lord.
Good morning.
Morning, my lord. I am in.
Are you in Mr. Joseph?
Dara?
Are you in Mr. Joseph Malia Bimiku?
No, my lord. I'm in Planzak Dara Godwin. versus Nigerian Bottling Company Limited.
Northwest.
They have not called up your matter.
Okay, my lord.
Wait for your turn.
Ask call, please.
Who is counsel in Mr. Joseph Mali Abimiku and Jos Electricity Distribution and Bingham University Teaching Hospital?
Let me talk to
10-5-23 for hearing notice on the parties.
As the court pleases.
Mr. John Choji and Access Pensions.
Yes, my lord.
Yes, can I have your appearances?
May it please, my lord. My name is W.J. Malti.
Mall. Spell it.
Yes, my lord. MWOLTIT.
Your connection is bad, counsel.
I don't know if my lord can hear me clearly now.
I can hear you now. Yes.
All right, my WJ Malti.
Your name again?
WJ Malti.
Spell it, please.
MWOLTIT.
Wait. MWO
LTIT.
I'll go back in the reference. Okay, no.
Yes, my lord. I bear with my learned friend, B.O. Boniface.
Yes.
I bear with B.O. Boniface.
B.O.
Boniface.
Can't hear you at all.
I don't know if my lord can hear me now.
I can hear you, Mr. Malti.
All right, my lord. I appear with B.O. Boniface.
B.O. Boniface.
Yes, my lord.
For the claimant?
Yes, my lord. For the claimant applicant.
Yes. Who appears for the defendant?
Lord, there seems to be no representation. At the last adjourned date, there was no representation. We only serve them with hearing notice against today's date.
Summary judgment.
Yes, my lord. Ready.
Take it in open court. I want to serve them with another hearing notice. The second convenient.
Second me. As a conclusion.
2-5, the defendant is to be served with another hearing notice matter adjourned to 2-5-23 for hearing of pending application.
As a conclusion.
I want to be completely satisfied that they have been notified more than once that there's an application for summary judgment and they choose and they refuse to show up in court before I take the application.
As a conclusion.
So hearing notice to be served on the defendants. Yes, who's counsel, Mrs. Mercy and Plateau State in government and 4 others. That's 8/2023. Mrs. Mercy Kiesduhun and Plateau State government. No appearance. Four 523 for further mention. Hearing notice on the parties.
As the court pleases.
Mrs. Fiona Dasgit, that's 920 and Plateau State government. Any appearance? That's 9/2023. NSN/Jos/9/2023. No appearance. Four 523 for further mention. Hearing notice on the parties.
As the court pleases.
Inspector Monday, Agam and 25 others and SEMCAT guards. Inspector Monday.
Yes, my lord.
Yes, my lord.
First Clement is in court, my lord.
Yes, appearances.
The greatest respect to my lord, DJ Gusen.
DJ Gusen, where's my friend Leonard Silk?
Sorry, my lord.
Where's the Leonard Silk?
Who is?
Where is the Leonard Silk?
Oh, sorry, my lord. He's in this force, man.
Give my regards. Yes, DJ Gusen
Thank
for
you,
the
my
good
lord.
month.
Yes, my lord. With I appear with LC Dabish. LC Dabish.
Yes.
Yes, my lord. We all appear for the claimants.
Yes, please. Who appears for the defendant?
Claimants are represented by the first claimant.
With profound respect, court,
Yes,
my name is A.M. Hassan.
A.M. Hassan.
Yes, my lord. I appear for the defendants.
Yes, please. Yes, please, gentlemen.
Yes, my lord. We have a motion before the court.
Is Mr. Gusen opposed?
It's not opposing. No counter has been filed.
Your application was filed when?
Our application is dated and filed the 6th day of March, 2023, my lord.
Mr. Gusen is not opposed, right?
Yes, my lord. It's just to come in, so I cannot oppose him.
So move in terms.
Before my lord, motion on notice dated and filed the 6th day of March 2023.
Yes.
My lord, the motion seeks the reliefs as contained on the face of the motion paper. And my
Yes.
lord, the motion not being opposed. We move in terms of the application and we respectfully urge my lord to grant same case of justice.
Motion file 6323 is hereby granted and ordered as paid. Matter adjourned to 18/5/23 for hearing.
The court pleases.
As the court pleases.
Agreed to my lord.
My lord, even though my lord, the matter was slated for hearing actually.
And you want to proceed?
My lord, we are ready with one witness.
After the court had adjourned the matter, I had instructed the registrar to list matters that do not require the taking of evidence.
Okay.
Virtual proceeding.
They're not properly.
So that if there are any pending applications, we clear up everything, we do all the housekeeping, so that when you're ready for hearing, we now proceed.
As a court pleases, my lord.
Physical court.
We are most grateful, my lord.
All right.
Thank you.
Plenty more Palm and 39 others.
Yes, my lord. NS Courtbook is representing the claimant.
Yes, Mr. Gigameki.
He's doing fine, my lord. I bring his warm regards to the honorable court.
Give him my regards as well. NS
I'll do
Courtbook,
that, my
right?
lord. Yes, my lord.
Who is
NS
your friend?
Courtbook. I appear for
Who is
the
your friend?
claimants. I do not know the friend of which my lord speaks.
No, see. Yes, Courtbook.
Yes, my lord, the matter is for mention.
Yes.
Our originating process has been duly served on the defendant. We are not in receipt of any process filed by the defendant.
You want a hearing date, right?
Yes, my lord, we urge that the matter be deemed as mentioned and we ask for a date for hearing.
(18/5/23) for hearing notice on the defendant.
As the court pleases, we're most grateful, my lord.
Thank you.
Hello, my lord.
Yes.
This is Desmond Umekwe, my lord.
And who may you be?
My lord, I'm the counsel representing the claimant in Joshua Ebiloma. For the judgment, sir.
Joshua Ebiloma.
Yes, my lord.
Where were you when the judgment was delivered?
Okay, my lord.
You had no idea?
I don't know, because I was trying to connect. The video was not connecting.
Well, the decision went in your favor, I believe. So you pick up a copy. I will send a copy down to Jos tomorrow.
As copy.
I believe the decision went in your favor.
As copy, I'm most grateful, sir.
Now, M6 2023, Plangzak Dara Godwin and Nigerian Bottling Company. Any appearances? Or 5/23 for further mention hearing notice on the parties.
As the court pleases.
Well, I believe that concludes today's proceedings. Thank you, gentlemen. Have a good day ahead.
Thank you, my lord. Have a good day too.
Yeah.
Close that door.